welcome to this panel and welcome to this event as well from the Council of Europe, which is a collaborator to this event. We attach a great importance that this event remains within the House of Europe, so to speak, which is open to all, as you have heard previously, but which is commemorating or celebrating rather this very August day. My name is Peter Kimpian. I'm the secretary to the Committee of Convention 108, and I'm joined on the stage and I will introduce you to the distinguished speakers in order of their first intervention. Erik Wennerström, the judge from Sweden of the European Court of Human Rights. Mohamed Diop, permanent secretary of the Personal Data Protection Commission of Senegal. Judith Lichtenberg, board member from the Review Committee on the Intelligence and Security Services in the Netherlands. And Emmanuel Netter is a professor of private law at the University of Strasbourg and the director of Master of Cyber Justice. As I said, we are celebrating today Data Protection Day, and I will not speak too much. I will spare you from my long speeches, which I deliver usually the committee on security, national security exceptions and the need to cooperate more with industry and businesses. But I just wanted to say that in 2006, the Committee of Ministers of the Council of Europe has decided to dedicate a day for the protection of personal data every year on the anniversary of the opening for signature of Convention 108. But what is Convention 108? This is the whole panel is about, but if you allow me just some introductory remark, which will not go along the usual speech I'm giving about the legal nature and the parties of the instrument, about appropriate level of protection and free flow of data. But I wanted to underline maybe this. Convention 108 is the instrument, I believe, which introduced at the very early stage a human-centered approach, if not humanity, into digital development, into automatic processing of personal data, requiring, back at the 80s, the time of CDs and old features and vintage stuff, which we call them now, that all progress happens with and for individuals at its center. Not one, not from a continent only, not from a group, but all of them. Even if we do the maths and count that it is now the 45th anniversary of the convention, and we're celebrating today the 20th Data Protection Day, we still have the room to celebrate, I believe, as this idea did not go out of fashion. Human dignity must always be at the center of anything we do with the machine, whether small or big, whether, as I said, a CD-ROM or a whole internet or a more sophisticated algorithm or large-scale digital processing. This is not a concept that is applicable only in certain locations or with regard to only certain data processing. Convention 108 serves also to reminding us about that, and Beatrice did a wonderful role in reminding us that it is a platform for cooperation that is open to any country in the world, and I would also dare to say all stakeholders in the world. But this idea is rooted in the principle which is fully aligned with the ones enunciated in the United Nations Declaration of Human Rights, that privacy is a universal individual human right. And it is applicable in South America, in Africa, Asia, and also in North America, in all continents. In consequence of this, all countries have negative and positive obligations, as you may know, to safeguard privacy. And some of them, 55 or even more, thinks that Convention 108 proved to help them in that. What I said at the beginning wants to concentrate a little bit more on that we should celebrate today. And my colleagues kept putting in some of our communication materials that we commemorate this word. I don't think we commemorate, we should celebrate this day, as even despite what is happening outside in the world or outside the area of data protection, we should celebrate that there are at least 33 countries with their institutions, governments, parliaments, data controllers. 2 more have joined us since last year, Greece and Monaco, that cherish the idea of placing humanity, humans, individuals in the center of development and of the future. So we celebrate today these 2 important features with speakers that are not necessarily involved directly with the work of the Committee of Convention 108 and give you a fuller representation on the place Convention 108 has in the international regulatory framework in the area of privacy and personal data protection. So Eric, can I ask you to give your first impressions and intervention?
Thank you so much. Good morning, everybody. Thank you so much, Peter. And can I also extend a warm thanks to Beatrice de Anchorena for her introductory words to this segment of the conference. I'm very grateful for having been invited. As has been alluded to already, the roots of European and indeed global data protection law go back much further than GDPR. We have to go to Strasbourg, 1981, when the first data protection convention was open for signature. The first legally binding international treaty dedicated entirely to the protection of personal data. Let me here, during my brief intervention, recall what Convention 108 is and why it still matters, and then go on to explain what Convention 108 Plus adds in response to new technologies. And let me also share with you how this convention influences the case law of the European Court of Human Rights that I represent, and what we can expect for the future. Although as a judge, I will naturally not be predicting any outcomes. The Data Protection Convention entered into force in 1985. At the time, computers did exist. No one spoke about the internet, at least no one I know. And big data was certainly not a concept back then. But in spite of this, if you look at the convention, it contains very modern ideas at the time. It had 3 core ambitions: to protect individuals against abuses, to harmonize national laws by obliging states to implement basic data protection principles in their domestic legislation. And thirdly, to regulate border data flows, ensuring that personal data would not be transferred to countries without adequate protection. Now, Convention 108 laid down principles that are now familiar to us all: the lawfulness and fairness of processing, purpose, limitation, data quality and security, and crucially, individual rights, which is principally my concern. It recognized the right of every person to know where the data about them were stored and to have inaccurate data corrected. And it prohibited the processing of sensitive data without appropriate legal safeguards. What made Convention 108 exceptional was its international character. As what a point made by the very fact that our keynote speaker is not from one of the Council of Europe member states. And from the very beginning, it was open to non-European or Council of Europe states. And today it has been ratified not only by all Council of Europe member states, but also by countries on other continents, such as Argentina, such as Mexico, Morocco, Tunisia, and Uruguay. In this sense, Convention 108 became the first global standard for data protection. And that's something to be proud of, I think. But of course, 1981 looks quite different than 2026. Artificial intelligence, biometric identification, large-scale surveillance, algorithmic decision-making, and global data flows. All these advances in technology have changed the landscape for which the convention was originally drawn to provide protection, which is why in 2018 the Council of Europe adopted the modernizing protocol, Convention 108+, with an objective not to replace the Data Protection Convention, but to update and strengthen this. I should say that this is quite normal for someone with my profession. I'm applying the European Convention for Human Rights, which has been updated 16 times since it was originally drafted. So this is what you do with conventions in order to keep abreast with times and developments. It's very normal. Now, 108 Plus introduces several major innovations. It strengthens the core principles of the original convention, and it extends the categories of sensitive data. It introduces new obligations concerning transparency and accountability, an obligation to notify personal data breaches, to inform individuals, and explicit requirements for privacy by design and by default. A fourth feature, and this is particularly important, the Convention 108 Plus recognizes new rights in the context of algorithmic decision-making. Now, individuals must be protected against purely automated decisions that significantly affect them, and must have access to meaningful information about the logic involved. It cannot remain a complete secret. 108 Plus reinforces the role of independent data protection authorities and strengthens their powers and enhances international cooperation between them. And finally, it also establishes a clearer and more coherent regime for cross-border data flows. In short, 108 Plus offers a robust, flexible, and global framework for data protection in the 21st century. However, one important point must be stressed and was stressed in the previous interventions: it is not yet enforced. It needs another 5 ratifications before it enters into force. Now, turning to the relationship between this regulatory regime and the European Court of Human Rights, I think it's fair to say that the Data Protection Convention, that is to say 108, goes far beyond treaty law. It plays a crucial role in the interpretation of Article 8 of the European Convention for Human Rights, which is the article that protects the right to respect for private life. Now, the court regularly refers to the Data Protection Convention as an authoritative instrument for defining what personal data and private life means. Looking at recent, over the past 2 decades, I should mention in Amman versus Switzerland and Rotary versus Romania in the year 2000, the court relied on Convention 108 to adopt a broad interpretation of private life. The court made it clear that private life includes not only intimate matters, but also professional and public activities. Public information may still fall under Article 8 of our convention when it's systematically collected and stored by authorities. This approach was reaffirmed in later cases, such as Haralambi versus Romania, Satakunda versus Finland, and even more recently in NF and others versus Russia from 2023. What is striking is that before and after 2018, our court continues to refer not to Convention 108 or not to Convention 108 Plus. It refers to the Data Protection Convention in the singular. Now, the court cannot wait for the 5 last ratifications in order to keep in pace with developments in time. When a case ends up before us, we must adjudicate whether the convention has entered into force or not. But I would put it to you, although the court does not, of course, take a position of what states should and states should not do with regard to ratification of new instruments, we have not yet adjudicated our first case on algorithmic decision-making. But when it comes before us, we must do so. And I would argue that the less of a modernized legal framework we have in our surroundings, the more innovative we would have to be in order to find the way through that algorithmic decision making. That's as close a judge can come to pronouncing an opinion in a particular direction. Now, the importance of Convention 108 is undeniable. And our court has said clearly that it underpins European data protection law and influences the interpretation of both Article 8 in our convention and also Article 8 of the EU Charter of Fundamental Rights. If we look ahead, let me conclude by taking a short look towards the future. Once Convention 108 Plus enters into force and is widely implemented, it will most likely influence the case law of the European Court of Human Rights too. It would be odd if it did not. But to the extent that the case law is not already adapting to the same developments that 108 Plus is trying to capture. Now we can expect the court to gradually refer it will not refer to 108 or 108 plus. It will keep on referring to the Data Protection Convention, updated or not. But it's going to be crucial when we come to cases in the future concerning artificial intelligence, which we haven't had yet, biometric surveillance, which to the best of my knowledge we haven't had yet, algorithmic profiling, which we haven't had yet, and also large-scale data sharing, which we have had certain variations of, and yet still have had to adjudicate. Now, Convention 108 Plus has the potential of becoming a global reference instrument for data protection, complementing GDPR and creating a common language between Europe and the rest of the world. Through the court's work, this convention continues to shape the very meaning of private life in Europe and beyond. Now, whether 108 Plus will truly transform protection on the ground will depend not only on ratifications, but on political will, institutional strength, and judicial interpretation. With this, I thank you so much for your attention and look forward to your questions.
Thank you. Thank you, Eric. From Strasbourg, let's go to Dakar, to Senegal. So what would be Mohamed, your take on Convention 108 and its use or relevance for you, for your work?
It's working? Okay, thank you. Thank you, Peter. Good morning, everyone. It's a pleasure, and we are very grateful and happy to be here to celebrate this day, Data Protection Day. Yes, I'm from Senegal, Data Protection Authority, one of the 54 countries in Africa which have data protection legal framework. And now of these 54 countries, now we have 44 countries that have a legal framework on data protection authorities. And in these 44, we have 34 countries, about 34 countries that have or that took in place data protection authority. And it's important for us today to participate on this celebration of data protection in international. And I just want to, before to answer this question, I would like to remind that Senegal ratified the Convention 108 in 2016, and at this time Senegal became the second country behind Mauritius to ratify the Convention 108. And with this accession, we have so far benefit from cooperation with the DPAs in the world of other states parties, but also our doctrine and our level of data protection has been raised through the work of the Convention Committee. It's an important tool for us, for Senegal. To give just one example, during the COVID-19, if you remember, the DPAs was asked to decide on the exceptional measure to take to be implemented to entering the monitoring of contact case relating on health data. And in Senegal, the joint declaration on the right to data protection in the context of COVID-19 pandemic by the former chair of the Convention Committee, Alessandra Pierucci, and Jean-Philippe Walter, the former data protection commissioner of the Council of Europe, served as a working basis for CDP to make recommendations to the health authorities of Senegal. That was a fantastic instrument, a fantastic tool for us to, to give recommendation to the health authorities of Senegal to address the issues of protecting health data in this pandemic. The importance for Senegal now of ratifying the Convention 108+. Today it seems clear that ratifying Convention 108+ is important for Senegal in order to continue to strengthening our national data protection legal framework and benefit from an adequate level of protection. And I would like to remind you that we have a new project of law, because our law in data protection was adopted in 2008, and now we have a new project of law. And during the drafting of the new project of law, the protocol amending the Convention 108 was a measure basis for us when we have a benchmark around the world, and we use it, the protocol amending the Convention 108. And in this draft law, we have, for example, implemented a new right for a person, for example, portability, and new measure, for example, for data controllers, like the mandatory to notify some violation or some file of data. In addition, the other objective was to able to ratify the Convention 108+, and for us it's urgent for us to ratify this Convention 108+ before we have to amend our law, and we hope till the end of the year, maybe at June 2006, we will have the new law. The draft will be passed on the National Assembly, and we hope that we will ratify the Convention 108+ before the end of the year or before June 2016. That's my first remarks. Thank you.
Thank you. Thank you so much. So coming back to Europe with Judith, but to an area which is not often discussed in public or debated. So thank you very much for accepting the invitation to speak about Convention 108 and your role, your job today.
Thank you, Peter. And also good morning, everyone. I will talk about what is perhaps, is it, doesn't it?
I don't, it's work?
Oh, okay. Yeah, so I will talk today about what is perhaps a niche in the Convention 108+. It's about the implications for oversight in the national security domain. And in doing so, I will first highlight a few additions or changes which are relevant to this topic. And then I will briefly reflect upon the restrictions and exemptions regimes in Article 11. So let me highlight three changes or additions. First, the Convention will bring an important change with respect to its scope. Under the convention, it is no longer possible to exempt data protection activities for certain activities or sectors, such as national security or law enforcement, from the scope of the convention. So this means that the convention does not rule out safeguards also when data processing takes place for national security purposes. And that's great progress. This being said, the scope of the convention must naturally be assessed in view of the restriction regimes listed in Article 11, but we'll get to that in a bit. The second change I wanted to highlight was already mentioned by Mr. Wennerstrom. The convention also provides for stronger oversight bodies. And then thirdly, I believe that the conventions, or that much of the convention's effectiveness on the ground depends on its precision and clarity. And that requires a common understanding of the key terms used in the convention. And given the challenges posed in our digital era by unprecedented surveillance capabilities, this is particularly important for the scope and limits of the restrictions and derogations listed in Article 11. And Mr. Wennerstrom was actually emphasizing how the convention is influencing case law, but I actually wanted to express that I believe it is very important that the case law is now also codified in the convention, especially with respect to important notions such as national security or the requirements for effective and independent oversight mechanisms. So now let me turn to the restrictions and exceptions. Article 11 has 3 exception regimes, and 2 of them are relevant for national security. The first paragraph actually contains a regime for a broad range of legitimate purposes related to general public interest, including protection of national security. And it allows state parties to derogate from specific provisions on condition that those derogations meet 3 criteria. They must be provided for by law, respect the essence of fundamental rights and freedoms, and it must be necessary and proportionate in a democratic society. And the third paragraph allows for 3 additional restrictions, but only for data processing for national security and defense purposes. And most notably is that they also allow state parties to derogate from some of the powers and functions of oversight bodies. So it is important to note that also restrictions concerning oversight must meet the test of being necessary and proportionate in a democratic society. Furthermore, I want to highlight that the third paragraph adds another requirement. The last sentence basically means that restrictions and derogations can never be affect the independence and effectiveness of oversight. So that's clearly an important safeguard. But the question has been raised how this safeguard can be ensured in cases where state parties derogate lawfully from certain provisions of oversight bodies, such as the provision that oversight bodies must have powers to intervene and investigate. So it is. It seems actually to reconcile this with this requirement that supervisory authorities named by state parties under Article 15 cannot be identical to those referred to in this third paragraph of Article 11. And so that's also in line with the fact that the Convention allows to name more than one supervisory body to ensure compliance with this Convention. And that's actually also how it works in my country, in the Netherlands. So we have a General Data Protection Authority who oversees the GDPR. And this DPA will also be responsible for to ensure compliance with Convention 108+. But this DPA does not have authority to review data processing activities of the Dutch National Intelligence and Security Services. And that is actually the responsibility of my organization. The CTIVD is an independent expert body tasked only with oversight of the Dutch intelligence and security services. So in that sense, I think also the CTIVD can be considered as a supervisory body within the meaning of the Convention. So let me conclude. Convention 108 plus sets important ground rules, also with respect to the processing of data processing for national security purposes. But this potential can only be realized if the scope and limitations of the restrictions and exemptions do not undermine the very essence of the Convention. And to address this challenge, I believe that two things are crucial. First is that those restrictions are interpreted in a limited and strict way, also in light of the case law of the European Court of Human Rights. And secondly, that it allows for effective and independent oversight mechanisms. Thank you.
Thank you so much. Manuel, we have heard some of the standards that are contained in Convention 108, but what do standards represent? And are they important or meaningful for you?
Thank you, Peter. Thank you to the EDPS and to the Council of Europe for inviting me. These past few days, I've been quite depressed, like many of you, I think. I wondered whether it might seem incongruous to discuss data protection while the scent of violence is spreading across the world. But you know the answer to that. You know it is quite the opposite. More than ever, we must speak of human rights, democracy, and the rule of law, the very motto of the Council of Europe. This is our core identity, and we must keep it in mind every moment in the years to come. So I want to show that Conventions 108 and 108 plus do nothing more, really, than transpose the fundamental values of the signatory states to the world of information in general, and digital information in particular. National or regional legislation are much harder to read, as they generally mix fundamental principles, supposedly indisputable and intangible, with the more mundane applications of these principles in terms of organizational structures, documentation types, distribution of roles and powers, and oversight and sanction procedures. Such a mix may seem inevitable, but it carries risks. The proposed reforms of the GDPR illustrate this. When the essential and the ancillary are intertwined, it's difficult to sort through everything. Convention 108 gives you a hint. For instance, if in this convention, the data subjects has a right to access to their data. And if in your projects you answer them, maybe you can access to your data, but maybe not. It depends. What do you want to do with that? Maybe you are not just tweaking details. Maybe you are tampering with the core actually. In Convention 108+, there are almost exclusively fundamental rules. A national or regional law cannot afford such a luxury, but Convention 108 can, and indeed must. It is what is expected of it, in my view. This is what makes it so precious. It provides much needed clarity. What does it fundamentally say? A small number of simple things. Data processing must have a clear objective. A balance must be sought between the interests involved. The purpose cannot be betrayed later on. Who can seriously oppose this? The information used must be adequate and relevant. Every effort must be made to ensure it is accurate. The data controller must demonstrate the utmost restraint, a form of data sobriety, from the outset, limiting collection to what is strictly necessary. These restraints also applies over time. Information that has become useless must be deleted. For the only data that is not at risk, you know it, is the data one does not possess. Who could argue that a single one of these rules is debatable? We could continue in this vein. Certain data, genetic, political opinions, health, sexual life, and so on, require enhanced protection. Measures must be taken to prevent the destruction of data, whether by accident or malice, as well as its disclosure to unauthorized persons. Who would oppose that? Obviously, nobody here, but it was a rhetorical question, so I'm not surprised. Finally, the rights of individuals, as envisioned by 108+, seem to me equally consensual and self-evident. Knowing what information is held about me in a file, requesting the correction of what is objectively false. Is this not common sense? Even when addressing a more recent and seemingly more controversial issue, such as the approach to fully automated decisions, 108+ remains very restrained, simply requiring, as you said, that the underlying logic is revealed and that the views of the data subject is taken into account. What should we take away from all this? In my view, Convention 108+ has crystallized what should be a universal consensus between states concerned with the fundamental right to data protection. This is not by luck or by chance. It is the result of tens of thousands of hours of work by the finest minds sent by the states to negotiate this text. The result of that work is just before your eyes. It is simultaneously a constitution, a compass, and a link. Had I come from a business school, it would have been 3 C's, and it would have been smarter. So maybe, I don't know, constitution, compass, and common ground. It is a constitution. There is, you know, this famous saying by John Potter Stockton that defines exactly what this means. He said that constitutions are chains with which men bind themselves in their moments of lucidity, that they may not die by a suicidal end in the day of their frenzy. Today, as we face global uncertainty, Convention 108+ is precisely that, a moment of collective lucidity. It is the chain that prevents us from sacrificing our fundamental freedoms on the altar of technological urgency or political turmoil. But 108+ is not just a restraint, it is also a compass. When new questions arise, it offers us paths to find constructive solutions while remaining faithful to our principles. I believe we will return to this point later. And finally, 108+ is a link or a common ground. The countries that have decided to respect the cardinal principles of data protection share something truly precious. It is easy to claim that one shares common values. Ratifying this text, and I insist, ratifying this text, is the proof of it. Being part of this community then offers significant practical benefits, which I believe we will also discuss a little later. Thank you.
Thank you so much. Thank you for your initial interventions. I've prepared some questions to you, but I would also like to ask the audience to prepare some questions. After 10 or 15 minutes, we will be giving you the floor to ask questions to the panel. So my first question, and now we turn a little bit on the more realistic side of things, or more deeping dive into what is maybe our daily life consists of. And one of the main criticisms was that Convention 108 is not implemented thoroughly, or is not harmonized within its outcome or their implementation. But Eric, what is your experience? Article 8 cases are among the top 3 at the ECHR. But are individuals, you think, are better protected in countries that have ratified Convention 108 plus, or the situation is pretty much the same in terms of complaints and where the complaints, or which country the complaints are coming from, and the situation will only be remedied by a more thorough implementation that could maybe start with an evaluation and follow-up mechanism that will kick in once the instrument enters into force?
Thank you very much. It's a very good question. If had a brief look at what statistics looked like over the past couple of years or so, and the answer is to your question is not a simple one. We could see with some caveats that countries that have ratified 108 plus show on an annual average 1.7 Article 8 violations per country against Article 8 of the Convention. Countries that have not ratified show about 2.25 violations per country. But this is really, the data does not show a significantly greater protective effect. Nothing jumps out at you when you look at that. Why is that? Well, probably because all these countries are already bound by Convention 108, its predecessor. I mean, they are following, the legislators of these countries are trying to keep in pace with technological developments through to 27 of our 46 member states under our jurisdiction are also EU member states, and will be adapting the legislation in accordance with the legislative imperatives that work there. So the legal baseline, in my view, appears to be already quite high. So ratifying 108 plus does not automatically change domestic practice overnight, I would imagine.
Thank you so much. Against this background, what do you think, Mohamed? Senegal should ratify Convention 108 plus? You said that it's of course important and it's a priority, but would you see as an urgent matter, given the change that we experience, including in Africa, the positive changes? There's a Malabo Convention, modernization ongoing, and many things regionally. So would be for you ratification an urgent matter?
Yeah, Peter, thank you. Yes, it's urgent for us, as I said, for Senegal and many of the countries in Africa to have the chance to have this international instrument in data protection. In Africa, we have one convention, the Malabo Convention. Unfortunately, this convention was in force only in 2023. And now in Africa, I think it's a great opportunity for our countries in Africa to join this convention 108 or 108 plus. And for us, it's a great it's a great instrument for Senegal, this convention 108, because as I said, we we strengthen our level of data protection framework. For example, when we have to deal with the data controllers, we use, for example, the contractual clause for data transfer. It's a fantastic, I can say, a fantastic tool to use to protect data controllers or data subjects in Senegal and in Africa. And I think after Senegal and the other 4 countries, Tunisia, Cabo Verde, Mauritius, and Morocco, I think other countries will follow to join these international cooperation in the Committee of Convention 108+, and it's urgent for us. And as I said, we are reviewing our law on data protection, and the Convention on 108+ was a great basis for our benchmarking work to align our legal framework on the international standard. Thank you.
Thank you so much. So if you allow me just a little personal experience, when I was working on the basis of a Macallan Convention and its implementation with my great predecessor, Sophie Kwasny, Macallan is about, it's a Council of Europe Open Convention. It's about sport integrity and requires a cooperation for private and public actors. And all police forces coming from EU countries were so much alert and also concerned how they would be able to share personal data, and how would they be able to work along the Macallan Convention. And we had a very good presentation from the Norwegian police that actually they demonstrated that applying the law enforcement directive and to a certain extent the GDPR made them decrease the number of investigations and improve the effectiveness and efficiency of the investigation. So that was truly remarkable. But I'm turning to you, Emmanuel. What do you think that these standards that we have in Convention 108 and to other data protection privacy regulations, are they compatible with the economic development? Because this is something which we heard. It's not only bound law enforcement authorities, but we hear that it's have an impact on economic development and innovation of new technologies.
Yes, we often hear the claim that personal data protection is an obstacle to technological progress and economic development, but you heard the DPS this morning. It's an old song and it's not true. I would first like to point out that we require companies, including SMEs, to comply with extremely complex rules in tax law, accounting law, social protection, consumer law, and well, in these fields, everybody is accustomed to that. Let's return to the idea that Convention 108+ is the constitution of data protection law. If a technological breakthrough suddenly emerges that head-on violates the principles of 108 or 108+, then we must rethink how we deploy that invention, not rethink our fundamental values. When, let's name the things. When ChatGPT was launched, I studied OpenAI's privacy policy with my students. Do you remember? At the time, there was practically nothing in that document, even though the tool already had hundreds of millions of users. These entrepreneurs always say, move fast and break things. But are we obliged to let them break things? That same ChatGPT could very well have been deployed a few months later with a carefully crafted privacy policy and a minimum of prior assessment. Yet, we accept the narrative that progress is unstoppable and so on. In these moments, we are weak, and that is our own fault. The reality is that the rise of AI is a powerful test for Convention 108+, proving, in fact, that its principles remain valid in all circumstances. Take, for instance, the principle of data minimizations. Some claimed it was incompatible with big data. So data protection authorities responded calmly, if you can demonstrate that you need such a depth of data to build a tool that is otherwise lawful and useful, then you may do so. Minimization is respected. And not only are the principles of 108+ not the enemies of AI, they are often its allies. The Convention forces us to question the quality of data, the relevance of data. And you know that we are currently discovering that LLMs trained on smaller but higher quality data sets may in the end be the most effective. One final reflection. Bad AI is good for no one, not even for those who sell it in the long run. We often hear that demanding authorities, and I quote, prevent the public from accessing new tools, end of quote. But once the initial excitement has faded, who would accept a situation where an LLM, in a moment of hallucination, accuses them of heinous crimes they did not commit? Who would accept a medical AI delivering a false diagnosis because its training data was biased and unrepresentative of the general population? Who would accept that a screening software denies a candidate in an interview simply because she's a woman? Nobody, I think. Thank you.
Thank you. Judith, conscious of time, I will combine the two questions I prepared for you, if it's okay. Will anything change in your work once the Netherlands ratify Convention 108+? And do you have maybe any expectations or wishes? And what are the main features, the facilitation of free flow of data and cooperation between national supervisory authority? Is this something meaningful, relevant to you in your work? And what are the changes that you expect in this field once the instrument enters into force?
Thank you. There are a lot of things, but let me say a couple of things. I'm not sure whether something will change in my work immediately. I would say no and yes. No, because the data or the law that arranges the work of the Dutch intelligence security services was established in the 80s and has been reviewed in consideration of Convention 108 and also the case law of the Human Rights Court. So the Dutch government now says the current act is completely up to date and fully in compliance with Convention 108+. And actually, we, to a largely extent, we agree to that, not fully. But the Dutch National Security Act is under review and it will be changed. And so, in that sense, I also have a wish, perhaps, and that there will be adopted further guidance on the restriction regimes in Article 11, because there is, due to the geopolitical situation, a lot of pressure to give the services more flexibility to do their job, and it is important to make sure that it is not at the cost of effective safeguards. And then perhaps, yes, I'm sort of jealous in when it comes to international cooperation between supervisory bodies. Ms. Beatrice, you also made it clear how important international cooperation is, also as a key element for protection of individuals. Bodies like mine, we are of course also allowed to cooperate with other supervisory authorities in the national security domain, but we are not allowed to share any state secrets. So actually we can only talk about procedures, and we cannot work together when there is data processing across borders. And that is only increasing also the services work a lot together with other services. So it would be great to avoid oversight gaps, that we as supervisory authorities also get some more room for cooperation. Thank you.
Thank you so much. I would like to open the floor for questions from the audience and from the online moderator. Okay, so I see a gentleman over here.
Good morning. My name is Giacomo Deli Navelli from ING Bank. I have two questions. One for Mr. Mohamed Diop. You mentioned a lot there is the sense of urgency in your country, but I need to admit I'm not familiar a lot with Senegal. What are the challenges that you have there in terms of data protection? Are the same as we have here in Europe? Is there something specific that you are facing there? And then the second question is for Ms. Judith Lichtenberg. In terms of still of cooperation, right? I see on the website of your organization that the scope of your oversight is mainly on intelligence services and in the military. But if we see the security more from a subject matter perspective, those entities also have collaboration, procurement, and operating also in a commercial environment, right? They receive data, they receive services from commercial parties. Does your oversight also extend on those agreements and procurements? And if no, do you cooperate with the National Data Protection Authority? How does it work in practice? Thank you.
So, please.
Thank you for the question about the main challenges we have faced in Senegal to ratify the Convention 108. I can say the main challenge for us is in Senegal, for example, we have many companies from Europe that transfer data to Senegal. Like the companies which work on offshoring, for example, and they ask us to have our legal framework aligned with the European legal framework like Convention 108 or 108 plus or GDPR. And that's why we start to review our law to make this compliant with Convention 108 plus and also to GDPR legal framework. And that's the main challenge we have faced today in Senegal and in Africa, I can say. And we have also the main challenges with European countries because, for example, for intelligent artificial or national security issues, we have to adapt our legal framework to align this legal framework with the international standard. Thank you.
It is correct, indeed, that the services also work with commercial parties. That falls under the scope of our oversight. However, it's only what we see on the side of the services. It's less clear if, for example, services have subscriptions, for example. We are in touch with the Dutch DPA, but it is actually very hard to work together in a concrete case because we are not allowed to share anything. So in practice, it has never happened that we work together with them in a concrete case. Thank you.
Thank you. Any other question? Question online? Yes.
Thank you, Peter. We have a question online as well from Alexandru Grigore. What would be the best way to encourage more countries to adhere to the Convention 108 and further implement those principles in their national laws? It seems to be really important in the current context where the big tech companies push really hard in the opposite direction, asking for deregulation in a digital wild, wild west. Thank you.
Okay, would like to pick up on this one. Maybe as we approach until the end, it can be also a summary if you wish to give, Emmanuel.
Well, a very strong argument in favor of ratifying this convention is what Ms. De Ancorona said. It's the free flow of data. Everyone here working with the GDPR on a daily basis, you know how hard it is to work in a fragmented landscape when it comes to data protection. It's very hard, and in the GDPR, you have tools when the third country does not benefit from an adequacy decision. You have the BCRs, you have the standard contractual clauses, but it's not even close to good tools. We do what we can, we are pragmatic, but it's not ideal. It's very complicated, and the results are mediocre at best. So if you want to continue to have economic exchanges, cultural exchanges between countries, you need to have a similar level of data protection. You need this. And Convention 108 Plus is the best tool to achieve this goal. So if you want to pursue this goal, if you want the great human conversation to continue between countries, you need the Convention 108, I think.
Eric, would you like to have some remarks on the Wild Wild West, or any closing remarks?
Thank you very much. No, just a reflection. What will it mean for the court when 108 Plus enters into force? Well, it will probably not be very dramatic for the court. As I said, the court is developing its case law and has done so ever since the first 108 entered into force. And as was mentioned by Ms. Lichtenberg here, the 108 Plus is also very much a result of the development of that case law. What I would see probably the greatest change is probably in the cooperation between the states forming part of our jurisdiction, in the common language that will be achieved by a unified legislative framework. So that is probably one of the changes that are likely to be visible from the court. Thank you.
Thank you. Is there any more question in the room or online? Yes.
So, thank you very much for the inspiring discussion. I am Loredana Tassone. I'm managing consultant at GRCI Solution, and so as such, I'm helping as a lawyer in compliance project organization worldwide. So I am really in line with the fact that the Convention 108 is a very core instrument. And in terms of what has been mentioned earlier, so there was a discussion in regards to the definition of personal data, which is a definition that we have since a long time, so with the Convention 108. And it was mentioned the fact that possibly there will be an interinstitutional dialogue. So in terms of how things will be shaped in the future, how the Council of Europe would participate in the dialogue in regards to the reform and modifications that would occur. So we have seen when the GDPR discussion were ongoing, the reform at the level of the Council of Europe was in parallel ongoing, and the Convention 108 Plus has been progressed. So is that something that would expect to occur also in the framework of the current reform? And this is one point. The other point is that I see the value of the convention also as a professional, in the sense that I use that while advising in the international data transfer matters. So, for example, if we need to assess in the framework of transfer impact assessment the level of compliance of the country that is not adequate, we would look at international standards and how the country in specific is looking at ensuring that principle and elements that are essential in order to ensure that the data subjects, individuals are protected, are handling it. So it's very core in this assessment. And I also see another practical aspect with the standard contractual clauses. And in regards to that, I would like to ask if it is possible to specify the reach of the standard contractual clauses elaborated at the level of the Council of Europe, and so how we could eventually, as professionals, apply that. Thanks a lot.
Would you like to, anyone comment before I give a? Yes, yeah, some from an institutional point of view, and I started with the House of Europe, and I'm very happy to close on that. So the European Union and Council of Europe is, of course, belongs to the House of Europe. They are the House of Europe, if I can, I dare to say so, but they are in a different floor. So European Union has internal processes which the Council of Europe will never interfere or never come into. So in that sense, we are not involved in the ongoing discussion as yet. But as we are in the same house, of course, we have a lot of interactions already at the level of the EU Council. We have an office in Brussels which are following the negotiations within the Council. We initiated we have a very strong and active cooperation with the EU Commission, in particular DG Justice in that. And should there be a need, we stand ready for any expertise or any support from our side. But for the time being, we understand that this is a purely internal EU process, which will not affect the commitments that EU or its member state took at the international level. So on the second question, on the SCCs, I can inform you that this is one of the main priority of the working program 2006-2009 that Beatrice mentioned, to promote SCCs and the wider use of FCCs. We call it in Strasbourg MCCs, but basically they are the same, so model contractual clauses. We have Switzerland already that have been approved, so all Swiss companies can use it already freely without any hindrance. And we are about drafting a strategy at the Secretariat. We are going to first discuss with the Bureau, and then we bring to the next plenary meeting in June how the best we can help authorities, especially data protection authorities and our parties, to approve them. Because if they are approved, then companies can use them very easily. And that might be also maybe further discussions in other forums. I'm not entering into this here because it would be a subject for another conference. But yes, there is an ongoing discussion, and we are very much interested to be part of this discussion about more convergence in data transfers. And we see, as a Council of Europe, has it within its priorities for 45 years that we contribute to this dialogue and to this discussion to help data controllers, businesses, sending data abroad, whatever they are, how big they are, or how small they are. So to summarize, if there is no more question, we are 2 minutes late, so very quickly to summarize, I think that it was a very good representation that persons coming not directly from the committee or are not directly involved in the work, everyday work of what we do in the committee level, demonstrated that data protection and data protection standards are not a niche subjects. So these are interdisciplinary and requires multi-stakeholder engagement and multi-stakeholder understanding and approach. And these approaches are not to be taken lightly, and many of them mentioned that these are, of course, flexible and should be applicable, and are applicable in many other jurisdictions, some of them different from the ones that we are operating in. But the flexibility doesn't mean lowering of standards or taking engagements with regards to protection of individuals lightly, or the commitments to ensure the free flow of data for the benefit of all. So thank you so much. Thank you for attending this panel. Thank you very much for the EDPS, for having us here, especially Romain, Valérie, Mr. Vivirovsky, and the whole team. Thank you so much. And I wish you a wonderful data protection day.